Good evening, friends. Good evening, one and all. And we are back with the part 2 of general principles of the gift, which is primarily dealt in section 124 to 129 of the Transfer of Property Act. And there couldn't be a better speaker who can make us understand the nuances of the gift and what are the principles which have been culled out with the flux of time. Justice Ramakrishnan has already taken one of the sessions on the part 1, that is the general principles of gift. More and all revolving under sections 124 to 129. Since the session was long, we had planned to divide it into 2 parts. Being a weekend, we understand that people who are actually loving the legal knowledge understanding are logging with us. And over to you, sir.
Thank you, Vikas, and good evening, everyone. Sorry for the inconvenience caused because of the power failure in Kerala due to the rain. In order to have the continuity and other thing, it is better that I can continue with the beginning. Start from the beginning itself. The last session, we have dealt with the gift in general. That is section 122 and how the gift can be made. Section 123 of the Transfer of Property Act. As you are aware, a gift is a voluntary transfer made without any consideration of both movable and immovable properties in existing, that is in presentity, belonging to the donor to a person called donee, and it must be a voluntary transfer and without consideration. These are all the 2 ingredients for the validity of the gift, because if there is any condition imposed restraining the right of the parties to do it or not to do it, or it is repugnant to the very purpose of the gift itself, the gift is invalid. And if it is with consideration, it will have the other nuances of the transfer. Either it may be by way of sale, or it may be by way of mortgage, or it may be by way of grant or lease, something like that. But gift is a one, just like a will. Will also there is no consideration, but will, as far as the will is concerned, it will take effect only after death of the testator. During the lifetime, he can revoke it at any time, and the last will only prevail. That is a general principle as regards the will is concerned. As far as the gift is concerned, once the gift is granted and it is accepted, then it can be revoked only if there is a condition imposed or subject to section 126 of the Transfer of Property Act. And the gift will not be accepted by the donee or on his behalf, and it must be accepted during the lifetime of the donor, and during the time at which the donor is capable of giving it. That is, he must be capable of contract, having sound disposal of mind, and he is also not affected by any disabilities. Legal disabilities, not the other disability, legal disability, not the physical disability. As regards the effecting the gift is concerned, section 123 says that in the case of an immovable property, it can be by a registered document signed by the donor or on his behalf. There is a power of attorney, if it is given for that purpose, that can be done, and attested by 2 or more witnesses. It is very important because it must be attested by 2 or more witnesses. It's a compulsory attestable document and a compulsory registrable document, and it must be accepted by the donee or on his behalf. But in the case of a movable property, registration is not compulsory, but it can be effected either orally or if it is by a registered document as well. Once a registered document is there, then you will have to comply with subsection 1 of section 126 of the 123 of the Transfer of Property Act. So it must be attested, it must be registered, it must be attested by 2 or more witnesses. So once, and In the case of a moved property, the transfer must be effected as in the case of sale of goods. How the goods will be delivered to the person and how it will be accepted. So the complete delivery of the movable property is necessary for that purpose. So this is the way in which the gift, general definition of gift and how it will be effected. Now we are dealing with the other part of the Transfer of Property Act, deals with gift. Section 124 to 129 of the Transfer of Property Act. We will deal with 126 later, how it can be revoked and what are the conditions under which it can be revoked. Section 124 of the Transfer of Property Act deals with the gift existing and future property. A gift comprising of both existing and future property is void as to the later, because as you are aware that the gift can be made in respect of a property in presente that must be available for delivery. It must be available, it must over which the donor has got right to dispose. It must have a vestige of interest in the donee immediately. If that is not possible, then there is no gift in respect of that portion. So that was the reason why this section says that in case where the gift is made in respect of both existing and future property, it is not totally void, but it will be void only to the extent of the future property in respect of which will not give, the gift will not come into effect. Section 125 of the Transfer of Property Act deals with gift to several persons of whom one does not accept. A gift of a thing to two or more donees of whom one does not accept it is void as to the interest which he would have taken had been accepted. So, in a case where a property has been gifted to more than one person or several persons, and if one of them did not accept it, then the gift is not totally void. It will be void only to, it will not take into effect only to the extent of the interest of the person who has not accepted the gift. And by virtue of non-acceptance of that portion of the gift by the person to whom it was given and who refused to accept it, it will not turn back to the other persons. They will not get the benefit of that because the intention of the donor is very specific and certain as to what is the nature of interest to be transferred in favor of the donee, and the donees will not get what more than what was intended by the donor is the principle behind this section. Section 127 of the Transfer of Property Act deals with onerous gift. That means a gift burdened with liability, where a gift is in the form of a single transfer to the same person of several things, of which one is and other are not burdened with obligation or liability, then the donee can take nothing by the gift unless he accepts it fully. Where the gift is in the form of two or more separate and independent transfer to the same person of several things, the donee is at liberty to accept one of them which is without liability and refuse to take the other which is not beneficial to him. In the case of a disqualified person, the donee not competent to contract and accepting property not bound by any obligation by its acceptance, but after becoming competent to contract and having aware of the obligation, he retains the property given, then he is bound by the obligation. There are two illustrations given. There, illustration A says A is having shares in two companies, with one having prosperity and other which is having prosperous nature, and the other is difficulties. And if the gift has been made in respect of both, in favor of B, unless B accepts both, he cannot, the gift will not come into effect, because it is by a same transaction, same document it has been done. But in the case where a transaction of lease with more liability than the value of the house, or normally the rent will have to be payable for that, and you will have to pay more rent. And also by virtue of another document, a gift has been made in respect of some portion of money without any obligation. Then, since it is a separate and independent document, the donee is having an option to accept the gift which is without any obligation and reject the other, so that, and in respect of the gift that has been without obligation is valid, and other is, since he is rejecting, it will not come into effect. So it is clear from this that in a case where the donor wants to give his properties with or without obligation by virtue of a single transaction to the same person, if it is a different person, position will be different. If it in respect to the same person, then unless the donee accepts both, he will not get anything, because he cannot have the option of election of accepting one and rejecting the other. But in the case where the gift is made by different documents, separate and independent documents containing the transactions, one in respect of a property burdened with liability and one without any liability, the donee will be getting an option either to accept the both or accept one and reject. But even merely because he has not accepted the property with obligation will not disentitle him from accepting the property which is beneficial to him. So that is clear from the illustration itself. Because illustration A says he is having shares in 2 or more companies, and he is gifting the property shares which is prosperous in nature and also with liabilities and with the difficulties to enforce it by virtue of the same transaction to the same person. Then the illustration says, unless the donee accepts both, he will not accept the beneficial one. So he will have to, in order to get the benefit of the transaction or the gift, he will have to accept both. He will have to accept the liability as well. Otherwise, he will not get. But at the same time, an illustration B says a lease of a property of a house with the liability to pay rent, which is more than the rent payable for a house of that nature. And he is also gifting an amount of rupees 10,000 to be by a separate documents. Then the donee can accept the amount and not refuse to accept the lease because it is not beneficial to him. And merely because he is accepting the gift which is beneficial to him will not disentitle him. He is not accepting the gift which is not beneficial to him, will not disentitle him by accepting the other which is beneficial to him, because it is a 2 separate documents. It's 2 separate transactions. It can be independently dealt with by the transferee. Section 128 of the Transfer of Property Act deals with universal donee, which says, subject to the provisions of section 127, because we read with section 127 is onerous gift. One thing I have mentioned, because in the case of a person disabled, even in the case of an onerous gift, the person under disability is not bound by the obligation or liability, even though he accepts the gift, because at that time he is not having the capacity to give consent. So in such cases, the person under disability can enjoy the property without obligation, but that will cease when he ceases, the liability ceases. Once the liability ceases and he is aware of the obligation that has been created by virtue of the document, and he retains the property for himself and enjoys it, then he is bound by the obligation that has been created by virtue of the document. So it is clear from this that a person under disability is always having a right to accept or not to accept during the after the period of liability, the disability disappears. And that will not be done within a reasonable period. If it is not done, and he is accepting, he is knowing, aware of the obligations made, and he is retaining the property, then he will be bound by the obligations that has been made there, because the cessation of liability will be there only during the existence of during the period of the disability and not otherwise. Section 128 of the Transfer of Property Act deals with universal donee, subject to provisions of section 127, where a gift consists of the donor's whole property. The donee is personally liable for all the debts due by the liability, due by and the liabilities of the donor at the time of gift to the extent of the property comprised therein. So it is clear from this, once a universal donee, because here also the acceptance is required, because gift is come into effect only if he accepts it. As far as the owner's universal donee is concerned, once he accepts it is in respect of the entire property is being given by the donor, with liability and without liability. And there are liabilities which may be more than the value that has been given. But once the donee accepts it, then he is bound by the liability created as per the document. He is personally liable for the debt, and there is a limitation provided to the extent of the value of the property that is comprised in the document, not otherwise. He will not be personally liable for the entire debt, only to send. That alone will be come into effect for that purpose, and he will be liable only to that extent, not more than that. See, there was one decision which says in one case, that is Sheikh Fatima versus Messrs. Venkata Chalapati Finance Corporation, AR 1978, Andhra Pradesh 401, where the donor had executed a gift deed in respect of all his properties except the salary as a teacher or some employment he is having. And there was a contention, the financial part, the finance company has filed a suit for recovery the amount, making the universal donee also a party to the proceedings. And he contended that since the entire property has not been given to me, he has retained some portion of the property, that is the salary. It cannot be said to be a universal. I cannot be said to be a universal donee. He can realize the amount from the salary that has been drawn by the owner, the donor. But the court said no, because as far as salary is concerned, you are aware, it is a recurring amount that is being payable to the person, and it is not a transferable right. We cannot transfer the salary to some other person. So if it is not a transferable one, then whatever possible transferable properties with the donor has already been transferred by virtue of this, that has been accepted by the donee. So the donee cannot now claim absolving from the liability of payment of the debts to the extent of the property that has been given. And the court held that he is liable. And also the same decision says that even in the case of after the death of the donor who made the universal, you make the universal donor the gift in favor of the donee, then he will be getting into the shoes of the donor as a legal representative, not as a legal heir, but a legal representative who is entitled to manage the property or intermeddle with the property. Because all of you are aware the difference between a heir and the legal representative. here include the here includes a legal representative, but legal representative, the legal representative need not be a heir, because in the case of a legatee need not be a heir of the testator, but by virtue of the legatee, he becomes the legal representative entitled to intermeddle with, by virtue of section the definition of the legal representative under the Code of Civil Procedure, he can be made party and he can be made responsible for the liabilities of the deceased person to the extent as mentioned in the section, because he will be getting into the shoes as a legal representative, not as a legal heir, but legal representative, and he will be liable for that extent. And even during the lifetime of the donor, suppose a suit will not be filed and the liability will be faced on a universal donee, unless the universal donee has been made a party to the proceedings, the liability cannot be enforced against him. So universal donee must be a necessary party to proceedings where the creditor wants to enforce a liability against the donor who had made a gift in respect of a universal donee of all his properties. Then universal donee must also be made a party for the purpose of making him liable for the liability. This was so held in the decision reported in Muhammad Gunye versus Muhammad Gunye, that is AR 1952, Tramagur, Cochin 23. So it is clear from this, and also it is somewhat connected with the Succession Act also, because universal donee gift can be made in respect of the entire property. Section 129 of the Treaty Act deals with the saving clauses of certain type of gift that has been made in respect of movable property in contemplation of death, that is mortem causa, and the Mohammedan law, which says it will apply to the gift of movable property made in contemplation of death, and not the rule of Mohammedan law dealing with gift. So in the case of a movable property, if a gift has been made while he was in deathbed, anticipating death, then it can be effected by orally by handing over the property. And the rule of Mohammedan law is not affected, is exempted from the provisions of the Transfer of Property Act. These are all the two conditions where the Transfer of Property Act deals with the gift is not applicable. And even in the case of a Mohammedan gift, Section 129 does not prevent the party to accept, to go by a document of gift. Then once he decided a gift will not be effected by way of a document, by a registered document, then they will have to follow the procedure provided under Section 123 of the Transfer of Property Act. Namely, it must be by a registered document executed by the donor or is on his behalf, and it must be attested by not less than 2 witnesses. And it must be accepted during the lifetime of the donor, and it can be accepted by the donee or is on his behalf. But when a gift has already been completed in respect of a Mohammedan, then and you want to execute a document to evidence the transaction of gift later after some time, then in such circumstances, even if a document has been created or executed, it does not require any registration because it is only evidencing an antecedent gift which has already been completed. But in the case where it is simultaneous, gift is being given and it is being taken effect only by virtue of the execution of the document, it is being done simultaneously, then it is a contemporaneous document to evidence the gift. Then it must follow the procedure provided under section 123, it must be registered, etc. Further, in the case where any dispute arose regarding the validity of the gift, as to whether the gift has been effected or not, whether it is valid or not, if there is any conflict between the Transfer of Property Act, provisions of the Transfer of Property Act and the Mohammedan law, then in order to resolve that issue, the latter will prevail. That is, the personal law in respect of the gift under the Mohammedan law will prevail. This was considered by the Andhra Pradesh High Court in Chota Ubandu Sahib versus Masron Bibi, that is AR 1975 AP 271. Now we will have to come to section 126 of the Transfer of Property Act, which deals with the revocation of the gift. Section 126 reads as follows. When a gift can be suspended or revoked, a donee and the donor may agree that on the happening of any specified event which does not depend on the will of the donor, a gift can be suspended or revoked subject to happening of that event. But a gift which the parties agree shall be revocable wholly or in part at the mere will of the donor is void wholly or in part as the case may be. A gift may also be revoked if any of the case, save for want of failure of consideration, in which if it were a contract, it might be rescinded. Save otherwise, a gift cannot be revoked. Nothing contained in this section shall be deemed to affect the right of a bona fide purchaser for consideration without notice. Two illustrations were given. A gives fields to B, reserving himself with B's assent the right to take back the field in case B and his descendants die before A, and B dies without descendants in A's lifetime. A may take back the gift. B, A gives a lakh of rupees to B, reserving to himself with B's assent the right to take back rupees 10,000 out of the 1 lakh. The gift holds good as regards 90,000, but it is void in respect of 10,000, which continues to belong to A. So, in order to have a concessional or the consensus revocation, it is clear from the section itself that there must be a condition in the gift that the gift will come into effect or take effect on happening of a specified event. And happening of that event is not at the will of the donor. And if it is agreed to by both the donor and donee, then if happening of that event, the gift can be revoked by the donor. But in case where a condition has been imposed, though the donee accepts or agrees for that condition, happening of a condition at the will of the donor, then the condition is either wholly or partly void, and the donee can take those portion of the gift which is not vitiated by the condition imposed. Because if you go by section 10, 11, 12, 13, and some other provisions in the TP Act, where certain restrictions can be made, to what extent the restrictions can affect the right of the party or enjoyment of the property is a matter to be considered by the court on the basis of the conditions imposed. And in all other cases, because the illustration A and B will give a clear picture as to how this can be done. Because in explanation, in the illustration A, the gift is subject to the B and his descendants not dying before A. Once that happens, because it is not within the will of the donor. Suppose B dies without descendants. Suppose he has descendants, probably the descendant may get it. But B dies without descendants during lifetime A. Then the donor can take back the property. It is revert back to the donor. Because what was intended by him is only in respect of the life interest that is in favor of the donee, and not the absolute right has not been given by virtue of the document. As regards the second illustration is concerned, he gives 1 lakh rupees to B, retaining power of using in respect of 10,000 rupees by himself. Thereby, he is not divesting with the 10,000. He is intended to give only 90,000 to the donee. And if that gift is even accepted by the donee for the condition, with that condition, the gift will be valid in respect of 90,000, and A can retain, the donor can retain 10,000 with him because it has not been intended to be gifted. He wants to retain the power of domain of user of that amount by himself. As regards the there also that comes whether it is a deficiency clause or a repugnant clause. Suppose if it is a deficiency clause giving certain restrictions or contingent or things to be happen, condition to happen, subsequent or condition precedent, then it will not be happening on the basis of the condition precedent and condition subsequent. If it is not fulfilled, then it can be revoked by the donor. But as regards the other aspects are concerned, it can be revoked once the gift is complete. Normally, it is irrevocable, and it can be revocable only as though it is a contract. And on what conditions a contract can be rescinded? Only on those conditions this can be possible. Further, it also saves the right of a bona fide purchaser for without notice, as provided under some of the provisions of the TP Act itself. In the case of a fraudulent transfer, or in the case of conditions imposed, onerous transfer that has been made without title, a transfer has been effected. In all those cases where the original title holder gets the right, then if he is a person who has purchased it without knowledge of without notice of this thing, then he will be protected to the extent provided under the TP Act. Not full extent, because he will have to prove so many things. He is a bona fide purchaser value. Suppose it is a sham document for the purpose of defeating the donor, then the donee will not be getting that benefit. So all those things depends upon evidence. So in all other cases, the gift can be revoked only on vitiating circumstances which are capable of rescinding the contract in case the contract is being challenged. They are undue influence, coercion, fraud, misrepresentation, and it is not an onerous gift, then merely because the donor executed a cancellation deed, it cannot be said that the cancellation deed is valid. The unilateral cancellation is not possible. You will have to go to the court, and that too can be done within a reasonable time, because he cannot prolong the litigation of challenging the gift after a long time, after the period is over, because you know very well that section 3 years is provided for the purpose of setting aside a document. If in the case of fraud, it will come from the date of the fraud. In all other cases, misrepresentation, etc., immediate. In the case of a coercion, once the coercion ceases and he free from the disability, he can do it. So you cannot prolong the same for a longer period. Further, variably in almost all decisions, I'm not going into the decisions on this aspect. In almost all decisions, it has been held that once the gift has been complete and prima facie there is no vitiating circumstances or suspicious circumstances made out, then there is a presumption in favor of the gift. Once the donor proves prima facie that there are vitiating circumstances, like under coercion it has been done, under the undue influence it has been done, or by mistake or misrepresentation has been done. Mistake also not mere mistake as understood by legal mistake. It has been done, or it has been done by trick or otherwise, without making him to understand the things in a correct manner. All those things will have an impact on the validity of the gift, and court, if it is satisfied that it has been obtained on account of these circumstances, then court will normally set aside the gift and give a verdict in favor of the donor who has been defrauded, who have been forced to execute a document, because the gift is a voluntary transfer. If it is an involuntary one, or made under coercion or certain threat, or due to some misrepresentation, he was taken to the registrar's office with some purpose, and the document which was not intended by was executed, or in respect of, suppose he went there for the purpose of executing a portion of the property, but the entire property without reserving any right to him has been given. In all such circumstances, if the court is satisfied that there is a misrepresentation made and he has been defrauded, then court will be inclined to grant a relief for the donor. In all other cases, it will not be done. But in the case of a liability that has been made, suppose in a case where gift has been made and the diversity of right interest has been provided in the earlier part of the gift, later a direction has been included that you will have to maintain me, then it is only a pious wish of the donor and it will not having an enforceable effect. But the position will be different. If a condition has been, the purpose of the gift itself is made for the purpose of maintaining him, with a hope that he will maintain, and on the condition that he will maintain, the gift has been made and it is accepted by the donee, then a violation of that condition will tantamount to a ground for revocation as provided under subsection 1 of section 126. The same provision has been provided under the Maintenance of Senior Citizens and Parents Act 2007, also section 23 deals with that. There also the court held, Supreme Court has said that merely because there was no direction in the document, but there was an understanding between the parties, that will not be sufficient for the maintenance tribunal to set aside the document unless there is a pleading and also a document. It has been specifically mentioned that there is a condition for maintaining the person who is making the gift during his lifetime. If there is a violation made by the donee, then the person, the senior citizen who made the transaction or the transfer is entitled to get back the property by setting aside document by filing an application before the maintenance tribunal. This was so held in the decision reported in Suja Kumar and other versus sub-collector and another. 2021 KHC online 3451. Because I don't get the, because it came in the live law and also in SEC also. And the same view has been affirmed by the full bench of the Kerala High Court in 2025 KLT 533. Subhashini versus sub-collector Kozhikode. And the burden is always on the person who is claiming the property. In the case of a coercion, in the case of a undue influence. Because once an undue influence has been established, the possibility of undue influence that is being established by the donor prima facie, that the burden is on the donee to prove that there was no undue influence and he was aware of all those aspects. Even in the case of the fraud, suppose the donor was aware of the fraud committed by the donee even at that time. At the time he executed the document, but he condones it and executes the document. Then a person who knows about the fraud and execute the document cannot later turn around and say that it was obtained by fraud and he is entitled to get back the document or property. And mere mistake or folly committed saying that under the impression that the donee will maintain me, I have gifted the property, will not be a ground for the donor to get revocation of the document unless it has been specifically made as a condition for executing the document itself in the gift deed and it was accepted by the donee. So it is clear from the provisions that normally, unless there is a condition of revocation of happening of certain events, which is not under the domain of the or at the will of the donor, then happening of that will give rise to an opportunity for the donor to revoke the will and he will get back the property. In all other cases, it is an irrevocable in nature and it will be revoked or it can be set aside only on the grounds mentioned of vitiating circumstances which it entitles the person to the contract to get the contract rescinded, and otherwise it is not revocable. With this, I hope that I can make the provisions of the gift as contemplated under the Transfer of Property Act to the extent possible, to the extent understood by me, which will be beneficial to you. And thank you very much for patiently hearing me on this aspect. Thank you very much.
Thank you, sir. So subtly explained that everyone can understand how you beautifully explained that thing. So two questions are there. If a gift deed of an immovable property is executed and notarized at a court, then how can it be disputed by other siblings on the grounds of malafide intent?
A gift deed has been executed
and notarized.
Notarized is not possible because the Act says that it must be registered. It is a compulsory registered document.
In terms of Section 17?
17, not only 17, Section 126, because Section 17 says an immovable property worth more than 100 rupees alone is subject to registration. But in respect of a gift under Section 126, no value has been provided. If a gift is made of an immovable property, it can be only by a registered document.
So that 100 rupees otherwise has paled into insignificance. That requires a relook.
The notarization will not validate.
No, I am saying the validity of rupees 100 for the purposes of registration. I say that it has paled into insignificance because
as far as the gift is concerned.
No, I'm saying rupees 100 has carries no value as such.
No value as such there.
Yeah.
Section 17 says immovable property worth more than 100 rupees alone requires to be registered.
That's what I'm trying to say, that it has lost its sheen within the flux of time.
Yes.
Rajiv, what would be the instances of gift being a contract as just expressed by you?
No, see, contract normally is an offer and acceptance. But as far as though it is a contract, it is without consideration, it is a voluntary transfer. As far as gift is concerned, if any circumstances have been made out to prove that it is not a voluntary transfer, but vitiated by certain other circumstances, then just like a contract, you can revoke it.
And one question is, when a senior citizen revokes a gift under the Senior Citizenship Act, whether the provisions of Section 126 of the TP Act would apply in such case or not?
No, because it is a summary remedy that has been provided for the purpose of setting aside a gift or any transfer made in contemplation of maintenance by the person who is receiving the property. This is a summary remedy provided in the full bench decision of the Kerala High Court. It has been specifically mentioned that the maintenance tribunal is only to consider the question as to whether the conditions are there or not. If the conditions are there, if they failed, they can do it. Otherwise, if it goes to the fraud or other aspects, then the maintenance tribunal will not get, because they will not be getting all the powers of the civil court to go into the question. That is what the full bench of the Kerala High Court says in 2000, I have mentioned earlier. That is 2025 KLT 533. That is Subhashini versus District Collector Kozhikode and another.
Thank you, sir. And tomorrow, friends, we would understand what directions have been given by the Honorable Supreme Court in Satendra Kumar Antal versus CBI, wherein various directions have been issued on right of bail, direction issued to different authorities. The session is by Justice Kuldeep Singh, a former judge from Punjab and Haryana High Court. So do stay connected with us tomorrow at 6 p.m. Namaskar. Jai.